Yes, Mr. Chichester Clerk, we've read the skeleton arguments and the judge's judgment.
I'm grateful for that. May it please the Court, I appear with my learned friend Mr Mark Baldock for the appellant, Mr Langdon, my learned friend Mr Andrew Grantham of Queen's Counsel is for the respondent, PSV. This is an appeal against a decision of the learned judge on two preliminary issues concerning the construction of Section 217. Permission to appeal was given by Lord Justice Newey on the 16th of February of this year. Subject to the Court's views, what I proposed to do this morning was to start by identifying the issues for this Court so far as we see them.
Yes.
Canter through the key chronology, key facts in the, they're agreed facts of course because this is a preliminary issue, canter through a chronology of those, then take the Court to the provisions themselves to have a look, ESS and Sully, which we will say leads on naturally to the second issue, and then I'd like to, if I may, address the two issues in reverse order and make some fairly short submissions on each of them. Yeah. Before turning to the issues so far as we see them, may I just refer the Court to, at the outset, to some of the terms that are used in the relevant provisions in the authorities. They can cause confusion themselves. 216, of course, of the Insolvency Act concerns a person that's involved in the management of two separate companies. And those companies are known by the same or a name which suggests an association between the second and the first. So the first of the terms that I was going to mention is liquidating company. And that's a company, of course, that trades under a name that is not prohibited at the time of its trading. And it's only after this first company, as you might call it, but sometimes they're not necessarily the first in time, goes into liquidation and that name becomes a prohibited name. And it's for that reason that the 2161 defines it a liquidating company. In the present case, the liquidating company was known as Discovery Yachts Limited prior to its liquidation. And accordingly, the prohibited name is Discovery Yachts. Another expression within the relevant provisions is any other company. Of course, Section 217 concerns the personal liability of a director or manager for the debts and liabilities of any other company which trades or continues to trade after the liquidation of the company under a name that's become prohibited by reason of the fact that it has the same name or an associated name. And for discussing the effect of the sections, they are variously, any other company is variously referred to as the second company, the successor company, or the prohibited name company. In the present case, the second company or successor company is known as Discovery Yachts Group Limited, and I'll call it DYGL if I may. And it was the holding company of a subsidiary, which was called Discovery Yachts Sales Limited, and that's DYSL. Finally, although the first target of the provisions are directors involved in the management of both the liquidating company and the successor company, they do extend to a variety of other persons who perform roles, and there are various formulations. I'm just going to refer to them as the director for the moment, but I don't mean to exclude the other definitions. So, if I may, the first issue, although the second in time, concerns the effect of Mr. Justice Tear's judgment against DYGL in the commercial court. The question on appeal, so far as we see it, is whether on a proper construction of Section 217 Insolvency Act, the judge was right to find that TJ's judgment against DYGL in the commercial court proceedings automatically establishes the liability of DYGL to pay damages for breach of contract, and in respect of which PSV now seeks to make Mr Langdon personally liable in these proceedings.
I'm slightly confused. The way you've put it,
I'm sorry.
the judgment, Mr. Justice Tear's judgment, was against DYGL.
The judgment,
Yes.
yes. In the commercial court proceedings,
Yes.
there were two defendants.
Yes.
DYSL, the subsidiary,
Yes. And DYGL.
and it was the one that sold the boat. And
Yeah.
there was DYGL, which was the holding company.
Yeah.
The claimants, Mr France and Elusive Yachting Limited, obtained a judgment which was undefended at the trial, as we'll see.
Yes.
And what the judge found was that that judgment automatically establishes, for the purposes of these proceedings, in which a constituent element is that my client is going to be personally liable for the company's debts, automatically establishes that liability.
Well, you're mixing up two different liabilities.
That's why I was just...
There's the liability of the company, that is DYGL, and there's the liability of your client.
Yes.
I don't see how you can say that the judgment doesn't automatically establish the liability of DYGL. That's the whole purpose of the judgment.
But
Whether it goes beyond that to establish the liability of your client
in respect of that liability,
in respect of that liability
That's
may be
the
a
point.
different question. But you started by asking, did it automatically establish the debt of DYGL? Well,
as
it
against
must,
my
but-
client in these proceedings, sorry, is what I meant to say, and I'm
Thank you.
obliged for sorting that out. I do apologise. But that is what I meant to say. And the point is, we say it should be open to Mr Langdon to defend himself in these proceedings on the basis that, in fact, DYGL didn't incur the relevant liability. And of course, that issue falls to be decided in circumstances where it's common ground that Mr Langdon wasn't a party to the proceedings, they weren't defended at trial, and in light of the judge's finding that there was no privity of interest between Mr Langdon and DYGL, and if he was wrong on the question of his construction of 217, that it automatically establishes the company's liability as against Mr Langdon, that Mr Langdon wouldn't have been stopped from defending these proceedings on the basis that it had not in fact incurred the liability. So that's the abuse point that the judge decides. He says one of the questions raised by my learned friend was whether my client might be stopped on the basis of abuse. And the judge said, no, subject to my conclusion that actually it automatically establishes the debt under Section 217. Just pausing there before we go on to the second issue.
I just want to be clear about what you are saying.
Yeah.
You're not saying, are you, that the judgment's got nothing to do with anything. You accept, I think, that it establishes, as against DYGL, that there was a debt.
Yes.
And that is
as between them.
And that is a debt of the company. So, do you accept that the existence of the judgment, I'm not talking about the reasons for it or judges' findings of fact, it's a court order, do you accept that the existence of that court order is at least prima facie material which establishes your client's liability? Or do you say you start with a completely clean sheet?
I say completely clean sheet, and my learned friend, I think, would say that also the other way around, in the sense that he accepted that if he was, if there was no automatic establishment of the debt, then it wasn't admissible at all, as against my client.
What is admissible?
I'm sorry.
We're not talking about the judge's reasons. I mean, we're not anything to do with Hollington and Hewthorne. We're talking about the court order.
Yes. Yes, ma'am. I mean, I think he would. I think he would accept that if he's wrong on the question of whether that judgment and order establish a debt, then it's not admissible at all. So I start with a clean sheet. And just before I go on to the second issue, I would just pause to say that we think it's worth bearing in mind what the bearing in mind the extreme consequences to which the statutory scheme, coupled with my learned friend's interpretation, gives rise. And I make the point by reference to the provisions in general and to this case and the agreed facts on this case.
Yeah.
In First Independent Finance, my Lord Justice Lewison pointed out that although the primary target of Section 216 is Phoenix situations, actually 216 doesn't distinguish between honest and unscrupulous traders or between good and bad Phoenix situations. So that means that an honest director may commit a criminal offence through inadvertent use of a prohibited name for which he is liable to be imprisoned or fined, and in respect of which the court has no power to absolve him. In addition, under Section 217, he will be personally liable for any and all debts and liabilities that the company incurs during the period in which the company uses the prohibited name.
He can apply, though, can't he, under Rule 22, in effect for dispensation, in the sense of being able to trade nevertheless?
There are the accepted cases, but if we're talking about inadvertent use, okay, culpable, but ignorant, but that is, the consequences are draconian. I mean, there's criminal offence and there is the removal of the limited liability protection.
But we're not concerned with the criminal liability in this case. I mean, even if you're right, that doesn't affect the criminal liability.
No, that's absolutely right, my lord. But what the point that I'm was endeavouring to make, and I was about to get to my learned friend's interpretation of the rules, of Section 217. We haven't got there yet. That's just, that's what we're bound by. That's the baseline, is the criminal liability and the civil liability to which I've referred. But on my learned friend's interpretation, a judgment is obtained by a creditor against a company in proceedings against the company. That's this case. That judgment automatically establishes a company liability for which the director is personally liable under Section 217, my lady's point, such as to preclude him from defending the existence of that company liability. That's this case. Even though he wasn't a party to those proceedings or privy to it, even though the judgment may not have, the proceedings may not have been defended at trial. That's this case. It could be a default judgment also, I suppose. He may not even know about it if he's a former director. And so far as he is concerned, the liability upon which the judgment is based is entirely fantastical. All of those.
What do you mean by that?
Well, if it's not hard to envisage a situation in which there is an insolvent situation in which numerous creditors put in claims of greatly varying in merit, some of which are meritorious, but some of those are totally fantastical,
Right.
so far as the director is concerned. But let's say judgment is obtained by default, or for whatever reason the company doesn't defend them at trial. He doesn't have the right to say, hold on a second, that's not a liability of the company. He just is shut down. It's automatic, according to my learned friend's interpretation.
Well, I don't think that's quite right. I think Mr. Grantham would say that your remedy in that situation is to apply under CPR 40.9 to set aside the judgment as being a person affected by it. And,
Well,
I mean, there are also circumstances in which a non-party can appeal against a judgment.
well, if it's an irregular judgment, if it's based on fraud or mistake, maybe. But the question is, I mean, let's assume there's been a full trial.
Yeah.
He has to set aside the judge's findings. So effectively that they're a mistake. It's, I mean, it is a huge, huge ask.
But your defence, as I say, your only defence is that this liability is not a debt of the company. You've got to be able to. You've got to say that, haven't you?
Yes. Well, I have two. There's a hypothesis, which is that actually it didn't fall within the period in which the company was using a
I follow,
prohibited
but you have to say this wasn't a debt of the company. You can't say, yes, I accept this was a debt of the company, but I'm not liable for it. So why is setting aside the judgment, thereby expunging the company's liability, not an adequate remedy for you?
Well, that would, to set aside the judgment, that would be on the basis that the judgment as between the company and the creditor was somehow wrongly given.
I.e., it's not a judgment, or it's not a debt of the company. The debt of the company must be a debt owed to the creditor. It can't be.
Yeah, but based on the evidence that was given in those proceedings, there's nothing wrong with that judgment. I mean, it's perfectly regular and standard. I mean, how far do you get with that? If it's a default judgment, take this case. It was undefended at trial. It hasn't been the subject of cross-examination, etc., etc. And the judge, of course, didn't place any weight in the end on that point. And it occurred to me this morning that it doesn't just apply to judgments of the court. If the logically, my friend's interpretation would lead to the conclusion that, and this will happen most of the time, one would have thought, in the case of liquidations, so an adjudication of proof of debts under the summary procedure, that, on my learned friend's logic, would be enough if they were admitted to establish a debt against my client.
But you can challenge a debt which has been admitted, the amount of the debt, whether it should have been admitted, whether it's been rejected, the amount in question.
My lady, I was looking at the rules just before court, and I don't think a director has locus.
But you're a creditor.
But you're a creditor and you're a shareholder, so you would have, wouldn't you?
And you're a creditor. You must be entitled.
On the facts of this case.
Well, you must be entitled to an indemnity from the company. If you pay a debt for which the company is primarily liable, you must be entitled to an indemnity from the company.
But my lord, that's a slightly different point from the one that I'm making. But what I'm saying is that if what my learned friend says is correct, then all he needs to do, all a creditor would need to do in a liquidation, would submit a proof of debt.
Yes.
That is decided under the summary procedure by the liquidator.
Yes.
And immediately, it won't be paid because the company's in insolvent liquidation. Immediately, hey presto, he has established the company's liability as against my client.
Well, unless your client, in his capacity as a person entitled to be indemnified by the company and therefore a creditor of the company, challenges it.
Well, he's only entitled to be indemnified if he pays it.
Not sure about that. Surety is entitled to indemnity before he pays.
I don't want to. It hadn't occurred to me that would be the way it worked. But if I may,
and I think it's. I can't remember the exact words of the rule, but I think it's shareholder, contributory, etc., etc. So you're likely to come within one of those.
I would, in my case, qua shareholder, but a director in general under the regime, I don't think would.
But it seems to us, I think, at the moment, that you are absolutely right to draw the analogy with, or the comparison with, an ordinary invoice. It's a good way of testing both sides' arguments, because it focuses attention, as I think you've already gathered, on the question, what is a debt of the company? And the debt of the company may be established by an invoice and then, as you say, admission to proof through the summary procedure or however it's dealt with, or it might be a judgment debt. And one can think of analogies with how things go in winding up petitions and so on. How do you prove your debt? Well, I've got a judgment. So, given that is the question, why can't one rely on the judgment as establishing the debt?
I think,
unless and until, of course, it's set aside or appealed or whatever.
well, my lord, it sort of depends on which side of you're looking at, whether it's a debt. If you're a company and you're on the end of a judgment, your remedy, if you have one, is to appeal.
Or it might be judgment into fault and you apply to set it aside.
Yeah, you might, exactly. And you decide to, or you don't.
And in this particular case, the judgment was given in the absence of the company at trial. So
yes.
That's another reason for setting aside.
Well, the company could.
Yeah.
The company could, it chose not to.
Well, I follow, but 40.9, coupled with whatever it is that allows you to set aside a judgment given in the absence of a party, would, one might have thought, give you the right to set it aside, to say this wasn't properly defended. Had it been, it's likely to succeed.
But the judgment, we don't say that the judgment wasn't obtained entirely regularly. I mean, what happened was the company went into administration shortly before the trial, as you will have seen.
Yeah.
Mr Justice Tier lifted the stay so that the administrator could participate if he wanted to. He said, no, I'm going to abide by the decision of the court. The company, which was insolvent by that stage, and this wasn't a decision, this isn't a situation where he was the owner and controlling just, the interests were aligned between him and the company. He was outvoted, I don't say he was outvoted, but there was a board of 5, and they resolved that it would go into administration and it wouldn't attend or be represented at trial. They didn't have the money.
Yeah.
So when the creditors come along, what immediately happens is when it turns out the defendants are not going to attend, Mr Justice Tier strikes that out and proceeds to hear the claim in the ordinary way. It's entirely regularly.
Yeah.
So,
So in fact, you say, well, I'm putting it in a pejorative fashion, but you don't challenge the fact that this is a debt of the company.
If you're looking at it from the point of view of the company.
From the point of view of the company, you do not challenge that this is a debt of the company. What you say is you can't enforce it against me without proving it against me. That is all. That is all you're saying.
Yes.
Thank you. Sorry.
If you're looking at it from my client's viewpoint, he hasn't had the chance to contest it. And I say that it is deeply uncertain whether he could set aside a regular judgment. Certainly couldn't invoke on the facts of this case the basis that it was obtained by fraud or on the basis of a mistake.
So you have to get into the words of Section 217, something which says the directors shall be liable for the relevant debts and liabilities of the company, jointly and severally, to the extent that those debts are proved against him.
Well, that would be if it was to make specific provision.
No, but that's the effect of what
Yeah,
you're saying.
yeah.
Because we're looking to
Yes.
try to construe the section, and so
Yes.
I'm trying to
Yeah.
put the words in that you need.
If, or to put it conversely, if my learned friend's construction was right, it might have said that it will be conclusive evidence, the judgment against a judgment or a decision of a liquidator will be conclusive evidence. It could be put on the basis of an evidential issue. And there's a couple of sections in the back of the supplemental bundle of authorities.
Yeah, which show that sometimes
It does.
decisions are evidence,
Yes.
not necessarily conclusive, but
They are not conclusive evidence.
They are evidence. Yeah.
Yeah. And that's basically, that's what we say about that.
Yeah.
That brings me to the second issue, which proceeds on the premise that DYGL entered into an oral contract with the claimants in the commercial proceedings in September 2017, and that it breached the contract in January 2018. It's common ground, I think, that the effect of this court's decision in Sully is that a director will only be liable for company debts and liabilities under Section 217, which were incurred at a time when the company was using a prohibited name in contravention of Section 216. Of course, the name became prohibited in between the date on which the contract was entered into in September 2017 and the date of the breach, according to the findings, which of course we don't accept, but according to the case that PSV advances and the assignors, the claimants advanced in the commercial proceedings. So the question for this court is whether DYGL's alleged liability was incurred for the purposes of Section 217 when the alleged contract was entered into by DYGL in September 2017 prior to the contravention, or when the contract was breached in January 2018 at the time it was using a prohibited name when it was said to have been breached. So much for that issue, unless the court has any questions.
Yeah.
If I could just canter through the agreed facts. They do appear in our skeleton at paragraph 12 onwards. But if I may, I'll just take the key dates. Matters begin in October 2015 when Mr France purchased the yacht, which was Elusive, from a company called DYSL, which I've referred to, under a 12-month warranty. That's the liquidating company. That's not the liquidating company. They purchased it from the sales company. The liquidating company was called Discovery Yachts Limited, and it built the boat, as far as I understand it. And that's the liquidating company.
Yeah. This is all in Section B, isn't it, of your...
It is. This is all in Section B.
Yeah.
I was just going to run through it because the sequence is important and it's quite... but yes, it is. And I'm not going to take through every date, I promise. I just wanted to go to the ones that seem to me to be important. Prior to April 2017, when there was a management buyout by Mr Langdon, the companies were owned by Mr Charnley. Mr Langdon became a director of DYSL and the liquidating company in August 2016. In April 2017, Mr France took delivery of Elusive through a special purpose vehicle called Elusive Yachting Limited, the second claimant in the commercial proceedings, and it was incorporated for the purpose of owning Elusive. Also in April 2017, Mr Langdon purchased the Discovery Yachts business through a company which he already owned, but changed the name to Discovery Yachts Group Limited, DYGL, which is the successor company. And when I say he purchased the business through that company, he purchased the sales company's shares and the assets of the liquidating company, but not the share capital of the liquidating company, which remained in the ownership of Mr Charnley.
But nothing turns on any of this.
No.
No.
The only thing I would say about this is that it does, what it highlights is the dangers of, or at least the difficulties that somebody who owns a small group of companies faces, potentially, and leaves one of them out, and it becomes, it's liquidated, and of course the rest of the group, which is owned by the defaulting director. So that's all it goes to.
I mean, the key dates are September 2017, that's the agreement that was relied on.
Yep.
October 2017, that's when the name became prohibited. January 18, that's when the breach took place.
Yes.
And maybe August 18, by which time Mr Langdon had lost control of the company.
Yeah. Yes, exactly so. 2009, and by 2019, and then the important, we get into the trial of the commercial court proceedings. That happens, as you will have seen, in December, about a week before DYSL and DYGL become insolvent, go into administration. As we've said, as we discussed earlier, Mr. Justice here lifted the stay. The administrator said he'd abide by the decision of the court. It wasn't defended by reason of the fact that it had been insolvent. My client wouldn't have been authorised to defend it. He had no idea at the time, of course, that he was going to end up being made liable as a 5% shareholder and one of 5 directors on the basis of this section. And one of the things that I think influenced the judge in deciding that there was no privity of interest between the two is that the interest of the company and the interests of Mr Langdon diverged, of course, because his personal interest would be to defend that claim, but he had no authorization to do so once he'd gone into administration. So that's the trial of the proceedings. TJ hands down judgment. On the 19th of December, he finds that DYGL had assumed liability, that's his words, through a Mr Bodine, who was an employee of sales, but not a director or whatever. Not a director of either company. And then he finds that there was this breach of the agreement when a Mr Gray tells Mr France that the parts for Elusive repairs will be provided, but not the repair, but not the labour. I think that's the.
Yes.
So that's it, and then we have the insolvency proceedings, which commence on the 31st of March 2020, and Master Boulder's order for the trial of preliminary issues. I was then going to just quickly go to the judge's judgment and to look at his decision on the what I would call the relevant debt issue, which is the second of the issues that we discussed, which will be behind divider 5 of the core bundle of documents. I was going to start by looking at paragraph 26, where he identifies it was the third preliminary issue, but this is the second issue for this court. And the way he put it, much better than I did to my lady earlier, was he said, the third preliminary issue is whether Mr Langdon is not in fact responsible for the relevant liabilities, that's the liabilities of the company, given that they derive from a contract which, based on the findings in the commercial court proceedings, was made at a time when Mr Langdon was not in breach of Section 216 of the Insolvency Act, even though the relevant breach of contract took place at a time when Mr Langdon was in breach of Section 216. This point arises on the basis that the relevant contract was entered into by DYGL in September 2017 and breach of the contract was in January 2018. However, the company of which Mr Langdon was previously a director, that's Discovery Yachts Limited, only entered into insolvent liquidation, thus triggering the breach in October 2017. And then the passage in which he deals with that second issue is from paragraphs 91 to 103 of his judgment. And just scrolling down to paragraph 101, this is his the crux of his decision. I have no hesitation in accepting Mr Grantham's submissions in relation to this point. The liability in this case is a liability to pay damages as a result of breach of contract. That's the way that my learned friend has put it here and below. The liability would not arise if there was no breach of the contract. It makes no sense to describe this as a secondary liability under the contract itself. It's a completely separate liability which arises as a result of the breach. The liability is incurred when the breach takes place, giving rise to a cause of action for breach of contract. And he concluded, of course, as a result, that the liability which PSV incurred was which PSV claimed was a relevant debt or liability within the meaning of Section 2173 on the basis that it incurred at the date of the breach in January 2018.
Am I right in thinking that Mr Langdon ceased to be a director by the time of trial?
I think it was after.
After?
I think it was after.
Right.
Because there was, yes, it was after, because he signs the Statement of Affairs, which at one point my learned friend relied on.
Yes.
But he then dropped that point because, of course, he signed that Statement of Affairs in his capacity as a director of the company. And from the company's point of view, there was no challenging that debt.
Yeah. No.
That judgment.
Right. Now, I was just wondering whether there was a distinction to be drawn between...
February 20.
I was just wondering whether there was a distinction to be drawn between the judge's order, that is Mr Justice Tier's order, awarding damages, and his order awarding interest and costs, which might be said to have been discretionary and therefore no liability until such time as the court exercised its discretion. But it sounds as though on the facts it makes no difference.
I don't think it does. Sad to say. The judge at 101 points out that the liability in damages would not have arisen without a breach of contract. We'd agree with that, of course. However, he then goes on to say that...
Sorry, just to pursue that last question. If you're right that the obligation or the debt arose when the contract was entered into, it might have a bearing, might it not, on interests and costs, because they were not incurred when the contract was entered into. They were incurred only because the judge Mr Justice Tier gave judgment for them.
Yeah, of course, it all,
So
I mean, in a sense...
Even if you're right on this second issue, you're still left with the interest of 22,000 odd and the costs.
Well, that is a point. But, I mean, no distinction was made or has been made up to this point. That's the first point. Hasn't been argued on that basis. It's too late now. But, of course, in a sense, it all derives from this contract at the beginning. Because if that contract doesn't exist, of course, there is no breach. If there's no breach, there's no claim, no proper claim, and no costs as a result. And if one steps back from a moment, that does sound remote, I understand that. But if one steps back on it, if the judgment goes, so far as my client is concerned, then the cost would follow the event. The cost order would go as well. It seems to me it's part and parcel of the same thing.
Well, on issue 1, you may be right about that, but as my lord has just put to you, why is it the same on issue 2?
Well, the best answer I can give to that is the one I think I've given in relation to issue 1, which is this, that if the judgment goes, then it seems to me that the cost order has to go because it followed the event.
Yes, as my Lord Lord Justice Arnold said, that's issue 1.
But I think it goes to issue 2
I see.
also, that point, if I may say so.
But you were saying, in relation to issue 2, there can't be a breach without a contract, and therefore we have to look back to the contract.
Yes.
But what we're looking for is when the relevant debt arose.
Yes.
So what is the connection directly between entering into the contract and the debt?
Well, the only one that I can give to you is the one that I've just given to you just now. But I mean, I'll start again from where I started off. I mean, this case has always been argued on the other side on the basis that the liability we're talking about is the liability to pay damages. No distinction has been made between. That's clear from my learned friend Skeleton here, Amber. But as I say, there is a causal link between the two. From my side, and that is what I say from Mr Langdon's perspective, if he's right that there is no company liability, and therefore he shouldn't be liable for the judgment, then the cost order can't stand as against him.
Yeah.
It must go too.
Right. I think we do understand that point.
I'm sorry, I've not made it very well, but that's what I can do with it. In any event, what the judge said about the liability to pay damages, because he says this is the liability with which he is concerned as a result of the breach of contract. What he says is that it followed from that fact that it made no sense to describe the liability to pay damages as a secondary liability under the contract, and accordingly that it was a completely separate liability. And we respectfully disagree with both propositions for reasons I'll come to in a moment. But as a matter of general principle in the context of Section 217, what we'd say is the liability to pay damages for breach of contract derives from the contract itself and can't properly be said to stand alone. Second, at paragraph 102, the judge found that Parliament must have intended to recompense an unpaid creditor of the prohibited name company, even if contravention occurred after the contract was entered into, because of the risk with Phoenix companies that they won't honour their obligations. And again, we'd respectfully disagree with that analysis. Again, I'll come to this in more detail in a minute, but we'd say that it's unlikely that Parliament would have intended to recompense creditors for losses that are attributable or properly... it's Parliament's intention to recompense creditors for losses that are attributable or properly attributable to the potential confusion to which these sections are directed, but not for the risks that would have occurred in any event in going into a contract with a limited liability company.
Okay, can we just test that proposition? Suppose
Yes.
that a company enters into a long-term contract which requires periodical payments to be made. And at some time during the currency of the contract, it becomes the company has a prohibited name. You say everything payable under the contract is attributable to the moment when the contract was made or when it becomes payable under the contract. Suppose it requires monthly payments or annual payments to be made.
Well, it would, I suppose, it would depend the precise nature of the obligation and when it fell. But I accept your point that in such a situation it might be more nuanced than the position that it is here. But if at the date that the contract has been entered into, those instalments are to be paid in any event, I would say that the die is being cast at the point of the contract.
Right.
Those obligations are in place. They are liabilities, albeit contingent or future ones. And therefore, it seems to me we'll come to the definitions in a minute of liabilities and obligations, but they're very widely defined under the rules. Rule 14.16, I think. But I would say, yes, the die is cast from the point of the contract. So the liability, if it's contingent or future, is at the date of the contract. And, of course, there is a secondary liability at the point of that the contract is entered into, which is the one to pay damages.
Isn't it implicit in that submission that the liability in question arises when the obligation to pay money arises? Because what you're saying is that if the contract provides for payments to be made in any event, the fact that they're to be paid in the future doesn't matter. There's still an obligation to pay money, and therefore there's a relevant liability. But in the situation with which we're concerned, there was no obligation to pay money until there was a breach.
No, there wasn't an obligation to pay money until there was a breach. There was a secondary obligation, contingent obligation, to pay damages in the event of a breach, and that arises by implication of law at the point under the contract, which must be at the point it's entered into. My Lords, I was going to go to the section first, but that question, maybe it would be sensible just to have a look at the width of the definitions under Rule 14. They are behind, in the full bundle of authority, should be behind divided 2.
Yep.
Page 11, 14.1, there's definitions of debt. The parts that I was going to just ask the court to read were sections 5 and 6 over the page on 12.
Yes.
In answer to my Lord Justice Arnold's question just now, just to note that in 6, last line includes any liability in contract. And in relation to my Lord Justice Lewison's question about present and future, well, it says what it says, so subsection 5. If we can then just have a quick look at section 217, which should be behind the previous divider 1 at page 8. The court will be aware that this is part of a statutory scheme which comprises sections 216, 217, and what's now part 22 of the insolvency rules, which contain the provisions allowing an application for leave to be made, and also the 3 accepted cases, one of which we may wish to look at in relation to the decision in Sully. As my Lord Justice Lewison pointed out in First Independent, although the scheme is primarily targeted at the Phoenix problem, broadly speaking, the Phoenix problem is simply where the liquidating company goes into insolvent liquidation at the expense of its creditors. The liquidators prevailed upon to transfer the liquidating company's assets to a successor company at undervalue, and then it proceeds to carry on the business under the same name or a name that's associated. And we know from Ad Valorem and Thorne that the current form goes much wider than the Phoenix type situation and deals with the potential for confusion or deception, as Lord Justice Chadwick put it in Sully, to third parties dealing with the prohibited name in a Phoenix type situation. My Lord Justice Lewison referred to creditors and suppliers as obvious individuals who are affected. Turning then just quickly to 216. 2161 provide that the provisions apply to a person who's been the director of a company within the 12 months prior to the day on which the company goes into insolvency liquidation. 2163 contains the prohibition on the use of a prohibited name by any other company. That must be potentially any other company other than the liquidating company, because of course it traded under a name that wasn't prohibited. And that prohibition begins on the day of the liquidating company's liquidation and lasts for 5 years. Then if you go back just to 2162, that's the definition of what a prohibited name is, which we are familiar with and discussed before. So one of the things that may be useful to consider before we go to 217 is what a contravention looks like, because of course that's a constituent element of the liability that you incur under Section 217. And the answer to that, I think, is that it's where four elements are present. First of all, there has to be a company, the liquidating company, which has gone into insolvent liquidation on a particular date. Second, there has to be another company which has used the same name or a name that suggests an association with a liquidating company. And of course, you know, plainly, a person is not in contravention. This is not there to punish people merely because the companies of which they're a director has gone into liquidation at the creditor's expense. And that's an obvious point, but an important one because of the fact that this is specific, we will say, Section 217 is specifically addressing the people who really might have lost out as a result. And those are people who are potentially confused by the use of the prohibited name. And, of course, they may well be creditors of the old company who want to continue trading, but they could, of course, be brand new creditors trading with the successor company. But they are, it is the creditors, potential creditors, of the successor company that we're talking about here. So these are people who are deciding that they're going into mutual obligations with the company, which there's going to be exchange of liabilities and debts. Third, you have to have the use or continue use by the second company of the name in question, and that use must have postdated the liquidating company's liquidation. Of course, in the present case, this is a group company type situation. It's not a successor company. I mean, the classic situation is when there's a new company that turns up after the liquidation of the liquidating company and assumes the new name. This is a group company where they were all using the Discovery Yachts name, but by reason of the liquidation of the company which belonged to somebody else, they automatically all became prohibited. And fourth, the relevant individual, the director, has to have acted as a director in the prescribed capacity for both the liquidating company and another company or companies. Moving on, I've referred to the contravention of Section 216, the fact that it is draconian in the sense that liability is automatic. There's no discretion to absolve a director from a criminal liability, and it's a liability to be imprisoned or a fine. And it extends to the honest director, even if he's culpable for not knowing that he ought to not have continued to use a name that became prohibited. With that, we can quickly look at 217. That provides the person who's involved in the management of the company in contravention of Section 216 is personally responsible on the literal wording of all the relevant debts of that company for the period at which time the director was involved in its management. And then the question of what a relevant debt is referred to in subsection 3. I'll just deal with A, but vis mutatis mutandis in relation to person who acts on instructions. And that, of course, provides that in relation to a person who's personally responsible under paragraph A of subsection 1, which is a person who's acting in contravention of Section 216, is liable for such debts and other liabilities of the company as are incurred at a time when that person was involved in the management of the company. That's the literal wording. And of course, that exposes a director, if the literal wording were correct, which we now know it isn't, that would expose a director to potentially unlimited liabilities, save limited only in respect of the time that he'd been a manager of the company, he'd been involved in its management. So it is not, on the literal wording, only the period, only the debts and liabilities incurred in the period in which the contravention occurs. And on the face of it, we would say that leads to an arbitrary result, out of all proportion. How can it be right that...
well, it isn't, because EAS and Sully says it's not, and
It's
and it's pretty obvious reading subsections 1 and 3 together.
My Lord. My Lord may be helpful to, in that case, I mean, maybe it is that I don't need to take you through the reasoning in Sully, which is
well, if you want it for anything else, then by all means do. But if you want it for the proposition that the relevant debts are limited to those which, during which they coincide, the director being a director of a company with a prohibited name and the incurring of the liability, then you don't need to take us to.
Indeed, my Lord. I mean, strictly speaking, this is obiter, but of course, it's an essential part of the reasoning. And I was going to take you through the various stages of her reasoning, but I don't think that that's necessary. It may just be helpful just to write down the words that they decided ought to be inserted at the end of subsection 3A, which were the words, I think. Sorry, I've just lost my reference.
Paragraph 75.
Thank you. And at the time when the company used a prohibited name, words to that effect. So that's Sully dealt with. In relation to the submissions that I was going to make following on the back of Sully, is this, that the Section 217 incurs a specific, a director incurs a specific measure of personal liability under Section 217 by reason of the removal of the limited liability protection that's normally afforded to him. That measure of liability is limited both by the debts incurred by the prohibited name company, by the extent of the time in which he was involved in its management, but also only at a time when there's a contravention of Section 216. And as my Lord has pointed out, the reasons for that are fairly obvious. No coherent and rational scheme would have imposed such an arbitrary penalty, we would say, and of course it offended the principles of doubtful penalisation. We've said, pursuant to the discussion we had earlier, our case is that the relevant liability was incurred at the time of the contract, and we say that that sits properly with the decision in ESS and Sully that the personal liability is limited to the period in which the contravention of Section 216 took place.
Yeah. So, I mean, to summarise this submission, you say, even if you're wrong on the first ground, and this is a debt of the company, it's not a relevant debt.
I do. And we've relied on the well-known passage from Lord Diplock. I don't know if you, from the jurisprudence in the law of contract, but in which he explains that there is a primary obligation to perform the contract and there's a secondary one. And applying the definitions that I took you to under the insolvency rules, so it's certainly wide enough to encompass both. There's also the decision of Mr. Justice Ryman re Millwall, which is referred to in my skeleton, which is in our skeleton, which is behind and core bundle of documents, divider 10, paragraph 58. I'd simply ask that the court read paragraph 58.
Yeah. Yes.
So, yes, it's not under Section 217, but it's Insolvency Act law jurisprudence. It's on all fours with the principle for which we contend. One last point on the question of relevant debt. The judge suggested that Parliament intended to recompense creditors of the prohibited name company because of the risk that they might not honour the debts, even if they entered into a binding obligation with the prohibited name company prior to the contravention. And we respectfully say that that misunderstands the nature and the purpose.
Sorry, can you just give me a paragraph in the judgment that you're referring to?
Yes. Sorry, if you go to the judgment, which is behind divider 5.
Mm-hmm. Paragraph 102, are you referring
That's
to?
it. That's it. We did. Yeah, we did look at it. But and this was my point about attributability. The mischief is of section, of section 216. It's the general potential for confusion. But section 217, as we now know, imposes personal liability on a director for such debts and obligations that are incurred at during the point of contravention. But if at the time the creditors entered those dealings, there was no breach of that prohibition, and accordingly no confusion or relevant confusion to the losses of creditors.
Can I just go back to an example I put to you a little earlier?
Yes.
Company enters into a long-term contract,
Yes.
which requires periodical payments to be made over a number of years. And at the time when it enters into that contract, it is a prohibited name company, and there is a director who is liable under section 217. On your argument, he is liable for everything that is going to be payable under that long-term contract, possibly for years and years.
Yes.
And you accept that?
Oh no. I mean, this is this question that, if I've understood the question correctly, this is the anomaly that the learned judge
This is what he refers to in 103.
Yes. And he accepted that it was anonymous because you could simply change the name of the company and therefore escape liability to a non-prohibited name after you've incurred.
I'm sorry, on your argument you couldn't. Because everything crystallises at the moment you enter into the contract.
Yes. On my argument, you couldn't do that.
Yeah.
On his, on the judge's interpretation, what you could do is realise that you were in contravention and simply avoid it by changing the name before you breached it,
yeah.
which just doesn't make sense in our respective submission. So those are my submissions on the relevant debt issue. I don't think I have to say very much more about the question of the automatic liability issue. I did hand up, I'm afraid, late, an authority which, funnily enough, was an appeal from the learned judge. The appeal was dismissed. But the Court of Appeal went through the authorities on Hollington and Newthorne and set out Gleeson and Whipple, which is, of course, the passage that I relied Sir Robert McGarry's memorable
I'm told
statement.
it's gone into tab 19 of the supplemental authorities.
Yes, and I'm hoping that I've got a hard copy.
Oh yes, Warden Saddle, yeah.
Yeah, if I can just give you the background very briefly, it's quite easy, really. And if you could just glance through the paragraphs as I do so.
Are we concerned with Hollington? We're not concerned with why the judge made the order he did, are we? We're just concerned, here is an order. He orders the company to pay a certain amount of money. We don't need to understand why, do we?
As I said earlier, you could, and perhaps it comes to the same thing. If you that establishing the debt by the judgment and conclusive evidence are effectively synonyms. In practice, that's what the judge is saying. That the judge is conclusive evidence. And another way of putting it is to say that the effect of the provisions is to elevate a judgment to a judgment in rem, essentially.
Yeah, but that's a different question, as is discussed in Warden Saddle.
Yes, my lord.
So as we were discussing earlier, you don't dispute that as against the company, the judgment establishes the debt.
I don't know.
And therefore, in that sense, you're not saying that Hollington and Hewthorne has any relevance, because that's all about admissibility of judgments as evidence to prove things. But as against the company, you accept, and if I may say so, you're obviously right to accept that it establishes the debt against the company. That's the whole purpose of it. But then you get into the question, which you rightly identify, it seems to me, as being the separate question, which is, well, what is the effect of the judgment as against your client? But that's not a Hollington and Hewthorne issue. Well, it's much more of a Whipple and Gleeson issue.
Well, my lord, I think it just might be as well. And the reason I say that, I detect it in my learned friend's repeated submissions that about its legal effect, which also, I noticed, found its way into the judgment. And that's one of the reasons I was looking at these cases. Sorry, let me just give you a reference. Go back to the judge's judgment. In the excitement of a new authority, I lost where he talks of what the judgment, what effect the judgment has.
Sorry, we're going to Mr Vos's judgment, are we?
Yes, sorry, this
Yeah.
is
You
paragraph
talk about-
41, page
Indeed,
53.
yes. Judgment inclusive evidence of its legal effect. In this case, the DYGL has been found liable to pay certain sums to Mr France and Elusive Yachting, and you don't dispute that.
It rather begs the question, though, it seemed to me when I reread this, legal effect, conclusive of its legal effect as between the company, etc., but as against whom? Is it conclusive of its legal effect as between the company and the creditor, but as against my client? Is this a lingering Hollington and Newthorne point, which is the one that was actually run by...
It's not Hollington and Hewthorne at all. Hollington and Hewthorne, you would say that the decision by Mr Justice Tier that DYGL entered into a contract on such and such a date and it breached it on such and such a date, that's Hollington and Hewthorne. But we're not concerned with that. All we're concerned with is that there is an order of the court which says DYGL must pay a quantified amount of money.
Yeah, and I say if it's based on a judgment that is, based on a judgment to which we were neither party nor privy it goes.
I understand.
But I'm not sure my learned friend has quite abandoned the idea that the legal effect as between the company and the creditor is an objective fact. And that's...
Well, how can it be anything other than an objective fact? It exists.
Well, that's where the evidence... That's why I say, is it conclusive evidence of that fact as against my client?
What fact? The fact that the judgment exists?
Yeah, the legal effect as between... the legal relationship as between the two. And I say it isn't.
I'm sorry, I didn't follow what you've just said. We have a judgment which is between a creditor and the company.
Yeah.
Now, that is a fact. There is a judgment.
Yes.
Now, I understand you say
It's
you don't care.
It's not evidence of its accuracy, not binding on me.
But you've already inserted evidence of its accuracy. Accuracy of what? There is a judgment and a judgment debt for a particular sum. The accuracy or otherwise, or as I think my Lord Justice Lewison was also alluding to, goes to perhaps the facts themselves. Was there a contract? How was it breached? Who said what to whom? Etc. etc.
Yeah.
But as I think also Lord Justice Lewison has said, we don't care about that, and neither does your client. In fact, because what Section 217 is about is there a debt of the company, a relevant debt of the company or relevant liability? And then the answer is there's a judgment debt. So generally, that's good evidence of a debt of the company. But your question is, does that apply to me? Or, under the wording of this section, have you got to prove that debt against me in order to make me liable under the section? That is different. It's not saying there is no judgment debt as between the creditor, original creditor, and the company. And I don't think, actually, despite the fact that you seem to have said different things, that you dispute that. There is a judgment debt. Its question is, what can be done with it?
Yes.
I'm sorry, I know we've been over this.
No.
You've said it.
My lady, that's absolutely right. I'm not disagreeing with anything at all that you've just said.
Yeah.
That is my position. The reason for Ward and Saville is that it seems to me that there is, I detect in the judgment, perhaps, certainly in my learned friend's skeleton, that what's being said is that the judgment is binding on me because the legal fact as between the two is a judgment on that question as against all of the world.
Yeah, but that's a separate question.
That is a separate
I mean, just to be, it might be helpful just to illustrate the points we've been discussing, just to look at the documents we're actually talking about. So if we go to the supplemental bundle, in tab 2, we have the order of Mr. Justice Tier. And so the key parts for our purposes are page 147, we've got judgment shall be entered for the first claimant against the first defendant in the sum of 9,11113. And then first defendant shall pay interest on the judgment sum, calculated, etc. And there's judgment for the second claimant against the second defendant's sum of, and so on. And then there's the payment on the costs, both defendants in paragraph 9, and so on. So whether you are proving an insolvency or in this scenario, what is relied upon is this document. This is the order of the court. This shows that there's a debt of the company. And for those purposes, nobody needs to place any reliance or indeed refer to at all the document we have at tab 1, which is the judgment of Mr. Justice Tier setting out the reasons for which he made that order. So we can forget about the judgment, and we can also forget about Hollington and Hewthorne. The question then is, what's the effect of the order as against your client? And your position is simple. You say, yes, it's a judgment against the company. It's not a judgment against me.
But it's based on a judgment in proceedings to which I was not party and not privy. So it has to go if I'm right that the judgment is not binding on me, the decision is not binding on me. There's simply, all the order does is give effect to the findings in the judgment.
Well, that's undoubtedly true, but why is the judgment of any relevance?
Because it is based on findings at a trial to which I was neither party nor privy. It's therefore the decision isn't binding on me. And the order to which it gives effect can't be.
But that's all reasons why you say it's not a judgment. The order doesn't affect you. You say, I wasn't a party and I wasn't privy. Therefore, the order has no effect against me. That's your argument. Well, it's got nothing to do with the reasoning in the underlying judgment.
But my learned friend's point is, well, it does affect you because it is one of the constituent elements of the claim to make you personally liable under Section 217.
So his argument is, he says, the order establishes a debt of the company. That's enough so long as the order stands.
Yes.
So that's the ambit of the dispute, is it?
Well, I mean, we have to hear what my learned friend says about it. What he says the legal effect of it is. But I simply say that for the purposes of Section 217, it has no effect as against me.
Yeah, absolutely.
And so you would say Section 217 should be interpreted to mean and to say a person is personally responsible for all the relevant debts of a company, even to the extent that those relevant debts are proved against him.
Yes.
But I suppose you may be entitled to say that if you confine your gaze to the order, it establishes that these sums are debts of the company, but not that they are relevant debts, because you only get the chronology, or the relevant chronology, from the judgment. You don't get it from the order.
My lord,
but
I would happily jump on that.
But then
train.
the problem on the facts of this case is that the facts are agreed so far as the chronology is concerned, so it doesn't really help you. I mean, there might be a case in which it might make a difference, that the judgment itself does not say, that the order itself does not clearly say
I take my
that the
lord's
debt
point
is a
on that.
relevant debt because of the time at which it was incurred. But I don't think that helps you on the facts of this case.
But it's still, I mean, I do still pray and aid the fact that at the heart of this, the underlying liability arose under the contract as at the date of the contract.
No, I understand
And the rest of it.
I understand that.
And that was not.
And to be fair, I don't think the judgment, the order rather, tells you why. It doesn't tell you anything about why the company is indebted. It doesn't tell you that it's a contract claim. It just tells you the company is indebted.
Well, the court has, Warden Savile, I'm happy to take you through it and to show you what the appellants were seeking to argue and the reason why I thought it might be.
Well, if you are extracting some relevant proposition from it, then of course show it to us.
Well, it seems to me that the effect of one effect of my learned friend's interpretation of this is that he is elevating the status of the decision on the legal effect as between the company and the creditor to one that is binding against other third parties. That's the thing that I'm guarding against.
Yeah.
That is what was argued before the Court of Appeal in Warden Savile and dismissed. Because it's based on a...
No, Warden Savile was about whether a judgment between, declarations, etc., between different parties entirely had an effect on a new party. So I think that...
Yes, exactly.
But in different, although similar circumstances. But
yes.
Different circumstances.
They are different circumstances.
Yes.
But what was said in that case, the declaration and the order provided for certain legal effects that, as regards the two parties, but which affected the third party, the wife who was married to one of the promoters who had the house in Notting Hill. May I just trouble you for a moment? I promise it won't take long. In this case, if you have it to hand, there were 65 claimants who claimed to have invested in fraudulent foreign finance scheme. The respondent, the third party, was married to one of the three promoters. The 65 claimants started their claims against the promoters, but there was a delay caused by a criminal prosecution, and the three of them were convicted of conspiracy and sentenced to 9 years imprisonment. Subsequently, they applied to join the respondent to the appeal, that is the promoter's wife, on the basis that her property in Notting Hill represented the traceable proceeds of the fraud. But she was never actually joined into the claim. The appellants obtained a default judgment against the defendants. I think she might have been subject to a freezing order.
They didn't go ahead with it.
Did they not go? No. In any event, the appellants obtained a default judgment. I mean, it would have been possible, of course, to get a freezing order against her, but without starting a claim against her. But on the basis of this declaration and order. So the declarations that they that the appellants obtained was that they'd been defrauded by the defendants, and this is where it may get interesting. The appellant had a proprietary interest in monies paid to the respondent, and they were entitled to trace those monies into the Notting Hill property.
Where do we find that?
That's at paragraph 14.
And she was not at that stage a defendant, is that right?
She was never a defendant.
She was never a defendant.
Never a defendant. But the declarations, of course, did, on their face, affect her.
Why?
Well, the appellants claimed that those declarations had legal effect as against her.
On their face, they don't. They're entitled to trace into the property of the first to seventh defendant's hands. That's what the declaration says. Paragraph 14. It doesn't say they're entitled to trace into anybody else's property.
Oh, sorry. One second.
I think it's really set out in paragraphs 15 and 16 of Sir Julian Flo's judgment.
Yeah, so they were pleading as against her on the back of those declarations.
But let us suppose, for argument's sake, that these declarations were declarations in rem, whatever that means. Good against the world, I suppose.
Yes,
what it
yes,
means.
in the thing, yeah.
How can a declaration that the claimants are entitled to trace into the property of Mr. and Mrs. Smith be read as a declaration that they're entitled to trace into the property of Mrs. Jones? I mean, how can you read it that way?
The grounds of appeal, 27.1, this is what was argued. In summary, the two grounds of appeal are that the judge was wrong to conclude that the judgment and order of Butcher J did not have such legal effect or consequences to enable the appellants to establish their proprietary claim against the respondent. That was the issue.
But how does that appeal get off the ground?
Well,
how do you interpret declaration that they're entitled to trace into the property of Mr. and Mrs. Smith as meaning they are also entitled to trace into the property of Mrs. Jones? I don't understand that.
If you go on to look at...
and the argument was rejected on that for that very
Yes.
reason at paragraph 76. Mm-hmm. You know, that was the first reason that was given for rejecting the argument that this was a judgment in rem. It was contrary to the terms of the order and the judgment.
Yeah, I think maybe the kernel of the submission is at 35. It was made. And I should say, I'm not suggesting that this is correct, where, of course, it would be against me. Mr Steinfeld QC relied in particular on the penultimate sentence. This is Hollington Hughes. The Thorno judgment, however, is conclusive against all persons of the existence of a state of things which actually affects when the existence of that state is a fact in issue.
Yes.
Now, I detect that same argument may be being run here, and I say it's simply wrong.
I see.
It's a misreading of Hollington Hughes.
Right.
It may not be put that way expressly, my learned friend will say, but there we are.
Right, is there anything else you want out of Ward and Saville?
No. You've seen Gleeson, Whipple, and all of them, so there's nothing. Thank you. I have my submission.
Thank you very much. Yes, Mr. Grantham.
My lords, my lady, in essence, the respondent submits the learned deputy judge correctly decided both preliminary issues for the reasons he gave as set out in my skeleton argument. Fundamentally, the issues are of statutory interpretation of sections 216 and 17 of the 1986 Act. And Lord, before addressing specifically grounds 1 and 2, as your lordship and your ladies will notice from my skeleton argument, there are some general propositions I'd like to make in relation to the principles of statutory construction. Lord, my lady, in paragraph 10 to 12 of my skeleton argument, I set out what I hope are relatively uncontroversial propositions as to the appropriate manner in which the court should address issues of statutory interpretation. They are derived, with the exception of paragraphs 12.3 and 12.4, from Benyon, which the court will know is in the core bundle of authorities behind tab 11. And I can take the court to the paragraphs if you would assist the court.
Well, I mean, I think we're reasonably familiar with the way that they
indeed
interpret statutes.
Well, the only paragraphs, Lord, which are not dealt with in Benyon are 12.3 and 12.4. They're both derived from Project Blue.
Yes.
But I believe them to be relatively uncontroversial for purposes of today. The other starting point, court will note, is that sections 216 and 217 are to be found in a part of the Insolvency Act dealing with malpractice before and during liquidation. And the court will note behind tab 1 of the core bundle of authorities, beginning at page 3 of the core bundle.
Yes.
The court will note sections 212, 13 and 14 before sections 16 and 17. And the reason for that is to set these provisions in the context in which they appear in the Act, which is malpractice on the part of directors. And of course, the liability in section 217, the civil liability, only arises in circumstances in which a criminal offence has been committed. A criminal offence which, as my learned friend has pointed out, may result in a fine or a prison sentence. My learned friend frequently pointed out the potentially draconian consequences of the application of sections 216 and 217. But the starting point is that that is the statutory scheme, that is the policy enacted in the Insolvency Act. As my learned friend has submitted, 216 and 217 also need to be read in conjunction with Rule 22 of the Insolvency Rules. And the significance of the insolvency rules in this context, and perhaps one can turn behind tab 2 of the core bundle of authorities, is to note very briefly the 3 accepted cases. The first case is in paragraph 22.4, page 19 of the core bundle of authorities. This arises where there is a sale by the liquidating company of its assets and the director serves a notice to all creditors. In other words, the first accepted case arises when the director in question has chosen to serve a notice, the effect of which is to exculpate himself from what would otherwise be liability.
Just a very small query.
Yes,
this is not your fault at all. But am I right in understanding that the document we have at page 19 contains a very strange typographical error in the numbering of the rules is not correct? So it should be 22.1, 22.2, then we have 22.3 correctly numbered. The next one is 22.4, and so on.
Your Lordship is entirely correct, and I can assist a little further, my Lord. At page 21, at the bottom of the page, should be 22.6. And I believe that completes the remedying of the missing numbers. The point to make from the first accepted case is that what it does, Lord, Lady, is to confer an entitlement upon a director in particular fact circumstances to exculpate himself from liability. 22.6 prescribes the circumstances and manner in which leave may be obtained by a director as contemplated in the provisions of 216.3 at page 8 behind tab 1. The 216 subsection 3, the court will note, provides at the outset, except with the leave of the court, or in such circumstances may be prescribed. What 22.6 does is to clarify the circumstances and manner in which an application for leave may be obtained. So, pausing there, the court will note there are two means by which a director may escape liability for what would otherwise be a contravention of 216 of the Act. And of course, as I note in paragraph 18 of the respondent's skeleton argument, it is always open for a director of a new company, the successor company, to resign as a director of that company. So there are three voluntary means by which a director may exculpate himself for what otherwise would be a criminal offence and the consequences of section 217. And what the respondent submits in paragraph 15 is that sections 216 and 17 of the Act, when read together with Rule 22, form part of the checks and balances associated with the privilege of limited liability trading. And they apply, as my learned friends pointed out, irrespective of whether the directors of the second company are scrupulous or otherwise. And that is a deliberate policy choice. Parliament might have chosen to enact a provision requiring dishonest conduct or unscrupulous conduct or some other form of culpability on the part of the director, but chose not to do so, obviously for sound policy reasons. Paragraph 16 of my skeleton, the court will note the principles that I say are to be derived from your Lordship's judgment in First Independent Factors and Mountford. And I'd merely invite the court to refer to paragraph 16. I can take the court to the relevant paragraphs should that be of assistance.
I mean, of course, in that case, it wasn't disputed that the debts were debts of the company. It wasn't said that any of the debts were invalid.
But absolutely not. I mean, as I shall develop in my submissions, one peculiar feature of this case is that this is a jurisdiction that has been on the statute book since 1986, and this appears to be the first case in which it has been suggested that a liability established against the company is insufficient for the director to be made personally liable.
Yeah.
And one of the authorities to which I refer in the supplemental bundle, the Archer case, was a case, I can take the court to it, but in essence, that was a case in which a default judgment was obtained against the company. The director pleaded that because there had been a default judgment, that was not sufficient. But when the matter came before the court, that was not the defence that the director chose to run. The director merely asserted a set-off. Now, that case doesn't decide that my learned friend's argument is bad, but it assumes it. And it is, as I say, highly significant in our respectful submission that this is the first case in which this argument appears to be run. The fact, we say, that it is perfectly legitimate for an assignee of a creditor of the successor company to utilise 217 is also, we say, critical, because it suggests that 217 is fundamentally concerned with enabling a creditor of the new company to extract value from the debts. The assignee may have far less knowledge of the circumstances giving rise to the debt, or the circumstances that might entitle him or her or it to rely upon the provisions of 216 or 217. The purpose of 217, which is submitted, was set out accurately by His Honour Judge Pearl, Queen's Counsel, in the Revenue and Use of and Bait case, which can be found in the core bundle of authorities behind tab 8. Forgive me, behind tab 7, I do apologise. And it's paragraph 33 at page 83. And it's the second sentence beginning at the end of the second line, just below letter F. And this was a point upon which the learned deputy judge specifically relied at paragraph 16.
So, wait a minute, so this decides that there is no right of indemnity which the director can pursue against the company.
That was the decision made, my lord, yes.
Right. So there was a point that I was putting to Mr Chichester Clark, but it's wrong in light of this decision.
On the basis of that decision,
Yeah.
I don't accept that, my lord. I was going to come to that in due course.
Right.
What the decision does, my lord, is to set out the rationale for 217, which is effectively to enable creditors and assignees of the creditors to extract value in the circumstances set out, to widen the pool of defendants.
Well, that way of putting it rather begs the question. You say widen the pool of defendants. Well, I think Mr Chichester Clark would agree with you. He would say, yes, you would sue me. You could have joined me in the original action as somebody potentially liable under Section 217, but you didn't.
Well, my lord, it doesn't follow from the fact that the rationale for the section is to widen the pool of potentially liable parties, then put it in a more neutral language, but all those parties have to be before court at the same time.
Well, I follow. So, I mean, you said pool of defendants, but what you mean is the pool of obligors.
Potentially liable parties or obligors, my lord, indeed. Obviously, it's our submission, my lord, that it is not necessary for the director to be before the court in the same proceedings as the liability of the company is established. What 217 is concerned with is enabling a creditor who is unable to execute a judgment against a company or otherwise enforce liability against the company to have recourse against another party that is liable in the circumstances set out in 216 and 217. Lord, in paragraph 20 of my skeleton argument, I set out the two circumstances which typically will arise when 217 is being utilised.
Yeah.
But I mean, I'm sure those are typical cases, but why would it not equally be used where there's an unpaid invoice?
This court is concerned today with the circumstances in which there is a judgment debt in which authoritatively a liability has been established.
To be sure. But suppose that the company, using the prohibited name, has failed to pay an invoice, regular invoice, has failed to pay it. Why might not Section 217 equally be relied upon in that case?
Because in that circumstance, my lord, the liability of the company has not been established as against the world. The effect of the order is to authoritatively determine that the company...
But it's surely the question. Question one is there a debt of the company?
Indeed.
And the creditor will say, here's my invoice. It's not been paid. Ergo, there's a debt of the company.
And what I say in response to that, my lord, is respectfully, but in that situation, there has not been an authoritative determination of the existence
What
of
if
the
the
debt.
liquidator admits it to proof?
Well, then, subject to the entitlement of the director in question to challenge that within the insolvency, on the basis it's a contributory, or he's a contributory, that would be an issue. There would have to be an application to the court in those circumstances. Of course, as your lordship rightly pointed out, under 40.9, if it's a judgment, the procedure would be to apply to set aside the judgment in question. And of course, as I shall develop, my lord, there would be nothing to stop the director applying to be joined to the proceedings in question.
But you accept that in relation to a judgment, there would be nothing to stop the director applying under CPR 40.9 to set aside the judgment which has been obtained against the company in order to show that there is not a debt of the company. Number one. Number two, in relation to an invoice, which is not our agreed facts, in relation to an invoice which is unpaid and has been admitted to proof by the liquidator, you accept that prima facie that again is a debt of the company for the purposes of Section 217, subject to the ability to challenge that, I'm probably using the wrong language, but admission to proof, in the sense that under the insolvency rules, as a contributory, one can say it shouldn't have been admitted, it should have been admitted for a lesser sum, etc., etc.
Milady, yes.
Thank you.
Clearly, that isn't the situation here, and there is a difference between an authoritative determination of a court and a liquidator administrator accepting a proof.
Yeah.
What I would obviously like to concentrate upon is the particular facts of this particular case in which there has been an authoritative determination, which is conclusive evidence of the content of the order.
Yes.
My lords, I'm sorry, the court, I was proposing to deal with the issues in the order in which they are formulated rather than the reverse order, but I'm happy to approach
You
this
take it in on the way you want to.
Well, since we've started on issue one already, you might as well continue.
Indeed, my lord. The analysis of the judge on this, which we say is impeccable, is in paragraph 61 of his judgment. That's behind tab 5 of the core bundle. And it's at page 57.
Paragraph 50.
61, milady.
61,
Page
thank you.
57.
Yep.
And that is the summary of what we say is the impeccable reasoning of the learned deputy judge in relation to issue 1. starting point is the fundamental principle of statutory interpretation, that the words of the statute read in their context, including the purpose of the provision. And if this point refers back to section 217 in the core bundle of authorities behind tab 1, page 8. This is 217, forgive me, subsection 1. And it's the opening line. A person is personally responsible for the relevant debts of a company. And my learned friend's appeal in relation to ground 1 involves the proposition that a judgment debt of a company is not a relevant debt of that company for the purpose of 217. And the respondent submits that simply does violence to the words of the statute. It cannot be argued, the respondent submits, that in that wording in section 217 does not render a director liable for a judgment debt of a company.
It's the same as the point I put to Mr. Chichester Clark, which is that you have to read in is personally responsible for all the relevant debts of a company to the extent that they've been proved against him.
Precisely so, my lady. That would have been open for Parliament to provide for, and clearly didn't do so. My lady, in paragraph 20, so caught out in paragraph 22, I refer to Phipps on evidence, but I refer to the passage.
What does Phipson mean by judgments in that passage? Does it mean the reasoning which leads a court to its conclusion, or the record of what it actually decided?
It would appear, my lord, to mean the formal record of the judgment. In other words, that which is contained within the order.
No, transposed to our case, it's Mr. Justice Tier's order and not his description of the reasons which led him to make that order.
Precisely so.
And in the case of a conviction or acquittal, it's the record of the Crown Court that such and such a person was sentenced to such and such, and that's it. That's
Indeed so, my lord.
Yeah.
And the fundamental proposition for which the respondent contends is that that is sufficient to establish the liability of the company.
Yeah. Does it? I can see that it establishes that there is a debt of the company, but does it, without more, establish that there is a relevant debt of the company? Because you cannot, from the order itself, deduce the chronology, or indeed what the sum is payable for.
How it is made up, what are the grounds of liability are.
Yeah.
Well, that is correct, clearly, from the basis of the wording behind tab 2. I say two things in response to that. I say, first of all, my lord, that on the facts of this particular case, that's a non-point because of the agreed statement of facts.
Yeah.
And one is entitled to have regard to that. The second point, I say, is this. One is entitled to have regard to the paperwork culminating in that order to interrogate the basis of the judgment. And
Well, then you're sailing quite close to Hollington.
I appreciate that, my lord. If I can refer your lordship to one highly unsatisfactory authority, but it is of some assistance. I say it's highly unsatisfactory because it's reported only in the English reports. Excuse me. Thank you. The court will bear with me for one moment. It is at page 156 of the supplemental bundle of authorities. This is one of the authorities referred to in 6. The redeeming feature of this authority is its brevity. Otherwise,
Green and the New River Company.
it is indeed. And the proposition for which that is authority, according to the learned entries of Phipson, which the court can find behind tab 10 of the core bundle of authorities at page 156.
I'm just trying to understand what's actually decided here.
What was decided in that case is that the verdicts against the proprietors of those may be respectively given evidence in action to be brought by them against their servants as to the quantum of damages. Now, that was
the first point in the case is that the servant was not a competent witness without a release because he was interested in the outcome.
Indeed so.
So it goes to the jury. Jury finds for the plaintiff whose horse has been damaged. And the court says that that verdict, oh I see, that the river company, is this right?
Yes, my lord.
Can then use that verdict in order to pursue the servant
Precisely so, my lord. And
for negligence.
Indeed so, my lord. And that's the proposition for which it's cited. And just so the court has, for the benefit of its note, it's at page 156 behind tab 10 of the core bundle of authorities, 4 lines down in the second paragraph beginning so.
I'm sorry, so what is the proposition that arises from that?
Proposition, lady, is this. It is permissible to interrogate an order, at least to understand the basis upon which the order has been made. Because if that were not the case, then in green it would not have been possible to rely upon the mere order to establish the liability, what the liability was in relation to.
So I think the argument goes a bit like this, doesn't it? The jury awards the plaintiff, let us suppose, £100 damages.
Yes, my lord.
It is known that the reason why the jury awarded the plaintiff £100 damages was that his horse had been injured because the water pipe burst.
Precisely so, my lord.
The water company now wants to sue the turncock, or whatever he was called, for failing to turn off the tap. If all you could do was to produce an award of £100 damages by a jury, you wouldn't know whether that was for damage to his horse or an assault or anything.
Exactly so, my lord.
So you must be able to show the context in which the award was made.
Precisely.
In order to recover from the turncock, although you can't use the jury's verdict to show that the turncock was in fact negligent.
Exactly so, my lord.
So when the court says the verdict can be used as to the quantum of damages, though not as to the fact of the injury, does that mean that the turncock is entitled to show that the plaintiff's horse never was injured? Or is it only entitled to show that he was negligent in causing that?
I say the former, my lord. I say that one cannot, in those circumstances, gainsay the fact of the injury, because that's the base upon the compensation.
Yeah. That seems to be the way that Phipson interprets it.
Indeed so, my lord. So I say, in response to your lordship's question, I apologise, it's taking a rather long time to answer it. I say two things more. First of all, I say the agreed facts are sufficient on the facts of this case.
Yeah, no, I understand that.
And secondly, I have this alternative argument.
So, might an alternative way of looking at that be this, and just using the facts of the case, present case, by way of example? Your starting point is the order made by Mr Justice Tier, and to some extent that's self-explanatory because it gives you the parties, it gives you the amounts. But insofar as you need to know more, then you could look at the pleadings.
Precisely so.
Because they would give you the context in which that order was made.
Precisely so.
So you would look at the claim form, particularly as a claim defence. That doesn't entail you looking at the reasoning in the judgment.
Exactly so.
Yes.
Lord, in paragraph 24 of Respondent's skeleton argument, we summarise the reasons we say the judge correctly
Yeah,
reached his decision.
yeah. Well, we read those.
I'm obliged. Lord, what I propose to do is to address the three arguments very briefly that my learned friend advances. These three reasons are the purpose of the legislation, principles of statutory construction, and then what I call supposed injustice to directors.
Yes.
I address the first matter, purpose of legislation, paragraphs 26 and 27 of my skeleton argument. We say, my lord, that the purpose of the legislation is common ground between the parties, as indeed the judge noted in paragraph 49 of his judgment, pages 54 to 55. Of the court lunch, I should say. And the judge took that into account in dealing with the proper interpretation of 217. The learned friend in skeleton argument refers to the Cork report, and all that I would say in response to that is that the Cork report, of course, wasn't referred at first instance, not least because the purpose of the legislation. Well, I didn't entertain the court further in relation to it.
But I think ESS and Sully seem to suggest that the origin of this legislation was not the Cork report, but it was the, whatever it was, Departmental Committee on Company Law Reform.
Exactly the same.
Lady Justice Arden refers to it.
An entirely different scheme emerged in 216, 217 from that which was contemplated in the Cork report. But not only was the purpose of legislation common ground, as noted by the judge, we say that the judge's interpretation actually furthers the purpose of the legislation, as set out by the Judge Pearl in the Elusive case. If the creditor or assignee were required in separate proceedings to prove the liability of a company, there is a clear and obvious risk of multiplicity of proceedings and a risk of inconsistent findings. That risk might be particularly acute if, for whatever reason, the director chose on behalf of his or her company not fully to defend the proceedings against the company in the knowledge that the company was approaching insolvency, but were separate proceedings to be commenced against him or her, to deploy all resources available to that director. Moreover, given that it might not be obvious for some time that the creditor or assignee might be entitled to rely upon 216, 217, there are limitation issues that might arise. By way of summary, therefore, I say purpose legislation was clearly furthered.
Limitation, if I remember rightly, stops running against a company in liquidation.
Yes, my Lord.
So do you say it would continue to run against, or might continue to run against the director?
My Lord, it may be that proceedings are commenced against the successor company which isn't wound up, but is unable to discharge the entirety of a debt. It is not wound up, limitation continues to run. By the time the proceedings are commenced against the director under 217, the limitation period has ceased to apply. But I entirely accept that if the successor company has been wound up, that the limitation against the company would cease to apply.
Yeah, I see.
But it wouldn't necessarily cease to apply against the director. In our submission, it probably would not cease to run against the director.
So when does time start to run against the director? I think this is a Pandora's box.
It is a Pandora's box. In my submission, my Lord, the limitation period would start to run at the same time as it starts to run against the company. Under 217 subsection 2, the two are jointly and severally liable.
Right.
So the limitation period, prima facie, would start to run from the date at which the company is liable. When the cause of action is
you stop the limitation period. Let's assume the successor company is solvent. You stop time running against the company by issuing your claim form
against the company, my Lord.
against the company. But if you're right, then time continues to run against the director. So you pursue your claim against the company to its conclusion. You then try and enforce against the company. The company can only pay you twopence in the pound, and therefore you wind it up. You're out of time against the director on your argument.
Yes.
Is that right? Well, how does that advance your case here? I don't quite understand how that
What I
works.
say is it's a reason why the purpose of the legislation is furthered by not requiring separate proceedings against the director.
Just because you say there'll be more lapse of time.
I say the creditors and the assignees would be prejudiced. I say they'd be prejudiced for a number of reasons. Obviously the costs, the risk of inconsistent findings, but also the potential, by the time that the creditor or assignee is aware of the circumstances giving rise to their entitlement to rely upon 217, that there may be a potential limitation defence that the director could run.
I'm sorry, I haven't followed this. Let us assume on the facts of the present case that the company's liability, relevant debt, was incurred in January 2018. I think is when the judge decided.
Indeed, so, my Lord.
Does time begin to run against the director in January 2018?
In my submission, logically, it ought to start to
Right.
run at the same time.
So if the creditor waits until after January 2024, the director has a good limitation defence.
Yes, my lord.
Right. Why is that different from the creditor bringing an independent claim against the director for alleging the same breach by the company before January 2024? I don't at the moment understand why it makes a difference. The limitation point.
Now, on the facts of this case, it's academic. What I'm saying is circumstances might arise in which proceedings are brought against the company at a time at which the creditor or assignee is not aware of the circumstances entitling that party to rely upon 217.
I'm just trying to think of a credible example where that would happen, where the director didn't have the same limitation defence.
No, what I'm suggesting, Lord, forgive me for interrupting, is this. If proceedings are commenced against the company but not against the director, during the course of the proceedings against the company, a limitation defence might become available, so that by the time of proceedings commenced against the director, that limitation bar would preclude separate proceedings against the director. I'm not sure that's sufficiently elegantly expressed.
Yeah.
What I'm saying, I'm merely advancing this as one of the reasons why the policy of the Act is served by not requiring separate proceedings.
Yeah, I understand, yes.
And I'm actually on to principles of statutory construction. My learned friend relies upon two.
Yes.
And Lord, I really address these in paragraphs 32 to 34 of my skeleton argument. In relation to ouster, all that I would seek to do is to refer the court to Benyon in the supplemental bundle behind tab 10. So page 235, forgive me.
Tab 10? No.
No, it's behind tab, forgive me, 15.
15. Right. Page?
235. The principle against doubtful penalisation is referred to at 234.
Yes.
The heading to which I refer your Lordship's attention, court's attention, is percent of presumption, 235. And I simply make the point that of all principles of statutory construction, it is subject to countervailing considerations, and what we say is that there are countervailing considerations in this case, including interests of creditors, the protection of which was the mischief at which 217 was clearly aimed.
Yeah.
Together with the fact that the director can exculpate himself or herself from liability. The judge addressed the principle of doubtful penalisation at paragraph 62 of his judgment, which is at 58 behind tab 5. Paragraph 62, it's the first paragraph at the top of page 58.
Yes.
So the judge clearly had in mind the principle, but was what we say correctly held that it did not displace the clear wording of the statute in circumstances which, on any analysis, the statute involved a penal consequence. I'd also refer the court to paragraphs 50 to 51 of the judgment, page 55. where the judge had regard to the, we say, very unfortunate consequences that would follow if the learned friend's interpretation of 217 were correct.
Yes.
Well, the respondent submits that any prejudice to the director has to be weighed against the prejudice to the creditors and assignees of the creditors of the company if the appellant's preferred construction were to be accepted. And I've already dealt with the consequences that might follow, including significant expenditure, risk of inconsistent findings, and multiplicity of proceedings.
Yes.
And we say any prejudice to directors needs to be seen in the context that, in all probability, the director has been involved throughout the proceedings against the company, might have knowledge of a precise case to be advanced against him, and in a position to gainsay that by reference to knowledge that he gains in the first set of proceedings, and might have chosen not to disclose the parlour's financial position of the company during the course of the first set of proceedings.
Yes.
The third submission my learned friend made in this context was supposed injustice to directors, and I address this in paragraph 35 of my skeleton, and I'd invite the court to refer to that.
Yes.
Which is a somewhat lengthy paragraph. Can I assist your lordship with any particular references?
I was just interested in this Archer case.
Well, that's a supplemental bundle of authorities.
Yeah. This was the set-off case you told us about. And you refer to paragraphs 30 and 35.
Yes, Lord.
This is Judge Kirkham, I see.
Yes, indeed. That's behind tab 7.
Yeah.
Paragraph 30 is at page 169.
Mr. Griffiths, I take it, is the director, is he?
Griffiths is the director, yes.
Paragraph 39.
And 35, which is on the following page, lady.
So he's saying insolvency set-off applied.
And the court said no.
Yeah, but it's 25 that sends out the point you were making earlier, that it was
That's
a
the
default
defence.
judgment.
Yes, ma'am.
And that's the point that was not pursued.
The facts are very briefly set out at page 166, paragraphs 4 to 9. And that just sets out the evolution of matters. And then, as your lordship pointed out at paragraph 25, that was the original defence, which wasn't used.
But I mean, just test that for a moment.
Yes, of course, Lord.
You sue the prohibited company. You recover a judgment against the prohibited company for £100,000,
Yes,
I
Lord.
suppose. And the prohibited company pays you a dividend of 50p in the pound. So you get 50,000 from the company. to that extent, the director, I would have thought, would not be liable to pay you 100,000, but only 50,000, because you've had 50,000 from the company.
One could not attain double recovery in most circumstances.
So why is insolvency set off different? The company is, in effect, deemed to have paid so much of the debt as is capable of being set off under insolvency set off. It's treated as if it were actual payment. That's the point of it. Well, do you want to give an answer at 2 o'clock?
Could I, my lord?
2 o'clock.
I'm obliged.